Welcome everybody to this Laws Community webinar. It's an absolute pleasure to bring this event to you this evening. Thank you to all of you who are joining us. There's a lot of interest in this event, unsurprisingly, on the UK Internal Market Bill. And I'm going to introduce our esteemed panel. I did just want to say something very briefly about the nature of this event. It's called a Laws Community seminar because we're bringing together our academics, our students, current and past, our alumni. It's something that we like to do when we're in the building, and even more important and special to do when we are all more fragmented than normal, and particularly on such an important legal topic. I'm going to introduce our panel. Many of you will know them. Some of you are probably being taught by them. Some of you have been taught by them in the past. Some of them are your colleagues, but I am going to introduce them formally, tell you a little bit about why they're wonderful, but also what their research interests are, because what's really remarkable about the topic this evening is that it crosses over lots of different complex areas of law. And so different areas of legal research and expertise are important to bring to bear on this topic. So first up, and I'm going to introduce my colleagues in order of who will be presenting. So there's no particular priority, it's just who's going to speak in what order. First will be Professor Jeff King. Jeff is a professor of public law and works on UK and comparative public law and constitutional theory. Jeff is the recipient of several research prizes. He's currently Special Advisor to the Constitution Committee of the House of Lords, which gives him a particular view on the topic that we're discussing this evening. After Jeff will be Professor Rick Rawlings. Rick is one of the UK's leading public lawyers, a Fellow of the British Academy. Previously held the post that Jeff is currently holding as Special Advisor to the Constitution Committee in the House of Lords. He's the author of so many works, but my personal favourite is Harlow and Rawlings' classic Law and Administration. And recently has been working on a major research project on devolution and a constitutional journey for Wales, which I think he will be bringing some insights from that perspective this evening. After Rick will be Professor Kimberly Trapp, who's Professor of Public International Law and our current Vice Dean International. Kimberly's research covers a range of issues in public international law, including state responsibility, judicial settlement of disputes, use of force in international law, and I hope we don't have to think about that this evening, and has advised, Kimberly's done many things, but amongst them advising NGOs and government departments on international human rights law, and also a lengthy publication record. And finally, our Dean, Professor Pete Eckhout, who is also has a very wide portfolio at the moment, which includes being Academic Director of the European Institute at UCL. Pete's research covers EU and international economic law, and he is his particular expertise is being caught up by this topic tonight because he looks at the relationship between different legal systems, including EU, WTO, international law, and UK law, which are all, I think, in play when thinking about the Internal Market Bill. He's the author of many leading works, particularly on EU external relations, and has various editorial positions, including being the founding editor of the open access journal Europe and the World, which I think is a very important perspective for the topic that we're talking about this evening. One quick point about how this webinar will run. Those speakers will speak in order, and then we'll be taking questions from the audience. Please do put questions in the Q&A box as we go through, and keep an eye on the questions that other people are putting, because you can vote them up if they're a question you would also like to ask, which is very helpful in figuring out which questions we're going to put to the panel. So without any more from me, I'm going to hand over to Professor Jeff King.
Thank you very much, Eloise, and it's an honor to be able to lead off this discussion. And part of my brief is to explain the background to the bill that's relevant to everyone else's talk as well. So I'm I'm going to say a few bits about the progress of the bill and the background to the bill. So this bill, the Internal Market Bill, is of central importance to the constitutional integrity of the UK, its union, as well as its international negotiating position vis-a-vis its two largest and most important trading partners. And notwithstanding that fact, the government decided to first consult on the proposals in this bill on the 16th of July, 2020. The consultation period stretched all the way across August, after which the bill was introduced in the Commons on the 9th of September and passed on the 29th of September. Then it's been mauled beyond recognition in the House of Lords, where it still remains. The government has there suffered more and larger defeats on key aspects of the bill than any other bill I can think of in recent memory. So what is it that this bill does? Why is it so incredibly controversial? Now, essentially, the devolved governments have regulatory powers under the devolution statutes. They track areas of EU jurisdiction and regulation for the most part. So the UK has in theory allowed devolved governments regulatory autonomy, which in practice has been essentially constrained by EU law on the same terms as it is for the rest of the UK. As we leave, that situation changes. The UK needs a regulatory framework of cooperation, or else the free movement of goods, services, and commerce could be obstructed. And this, I think, the need for some kind of framework, I believe, is fairly common ground among all four nations in the UK, which is a rare feat these days. Now, the Internal Market Bill is the government's answer to this problem. The general purpose of the bill is to, quote, preserve the UK internal market, end quote, by providing rules for the mutual recognition and non-discrimination of goods, services, and professional qualifications. That's the subject matter of parts 2 to 4 of the bill. And a new monitoring office is to be created under the aegis of the Competition Markets Authority, which is a non-ministerial department under the authority of the UK government. It has little formal legal relationship to the devolved governments, apart from having offices in each capital. This is among the controversial bits. Now, the way in which these proposals were developed, as well as their content, was hugely controversial, especially among the devolved nations. And that's going to be the subject of Rick Rawlings' talk today. We can call it the devolution problem. Now, whatever the drama of the other problems of this bill, in my view, that is the biggest constitutional issue in the bill. And as you'll soon see, that is saying a lot. The other major UK constitutional issue is the rule of law problem. So let me just outline what its genesis is. The internal market issue at the core of this bill is not just about regulatory harmony. The movement of goods between Northern Ireland and Great Britain is a deep constitutional issue that goes to the core of the peace process in Northern Ireland. To keep the Republic of Ireland in the EU customs union means there needs to be some sort of customs check. Notionally, that's arguably a border, at least for goods. And that needs to go somewhere. The question is where. For the Unionist or Protestant community in Northern Ireland, any kind of border down the Irish Sea is tantamount to being separated from the UK and annexed to Ireland. For the nationalist or Catholic community, a border between Northern Ireland and the Republic of Ireland is a sign of huge retrogression in the peace process. Border checkpoints were literally a theater of war during the Troubles. The Republic of Ireland is keenly aware of its duty to maintain confidence in the peace process, and the EU has stood by it. So how to resolve the border question, which is essential for the EU's customs union arrangements, was the most significant issue holding up the conclusion of the withdrawal agreement between the UK and the EU last fall and winter. The UK negotiated with the EU, and famously Boris Johnson negotiated directly with the Irish Taoiseach in October 2019. There were famous pictures of them taking walks together and finding common ground at last. The result of the negotiations was the Northern Ireland Protocol, a document annexed to the withdrawal agreement between the UK and the EU. Both of these were made part of UK law in the EU Withdrawal Agreement Act of 2020. Now, the protocol, in a way, has been called an instrument that has constructive ambiguity. That's a term that's previously applied to arrangements in Northern Ireland. In a way, it sought to have things both ways. So as it's described in the explanatory notes of the Withdrawal Agreement Act, it provides arrangements that ensure that the UK, including Northern Ireland, does not remain in a customs union with the European Union. That's one objective. Another is that the protocol also makes arrangements seeking to ensure that there are no checks and controls conducted at or near the border of Northern Ireland and Ireland, as well as providing that the arrangements contained in the protocol are subject to democratic consent in Northern Ireland. So the protocol is essentially trying to respect the provisions of the Good Friday Agreement, the idea that there should be no firm border either between the Republic and Northern Ireland, nor between the Great Britain and Northern Ireland. And it sets out a number of principles in the protocol that are essentially set up to try to achieve these goals. And there are three that are important. First, that goods going from the UK to Northern Ireland would not have customs duties applied to them unless those goods are at serious risk of moving on further from Northern Ireland into Ireland. Now, the bill doesn't address that particular provision of the Northern Ireland Protocol. However, it does address the next two. The second of the key principles I mentioned is that there should be unfettered movement of goods from Northern Ireland into Great Britain. And Article 6 of the protocol addresses this particular issue. And essentially it says there should be unfettered access and that both parties will use best endeavors to ensure that the unfettered movement of these goods is compatible with the EU's broader international obligations. It's foreseen that if goods just pass through from the EU through Northern Ireland into the UK and are then sold abroad, it's violating the principles of the customs union. It wasn't determined exactly how this problem was going to be resolved. The third principle in the protocol is that EU state aid rules would apply to Northern Ireland. So the protocol was a system in which the two parties put off the hard decision-making about how to resolve these knotty issues. What's happened is that Part 5 of the bill, as passed by the Commons and brought to the House of Lords, in this part, the UK government has sought to create delegated powers under which it could reinterpret and ultimately disapply the provisions not only of the Northern Ireland Protocol, but of the withdrawal agreement itself. And it would ensure to this end that these powers in Part 5 would be immune from control under principles of domestic law. And this is where the rule of law issues that I will speak about, this is where the international law issues that Kimberly Trapp will speak about, and the relations with the EU, which I believe is the main focus of Pete Eckhout's talk, are located on these provisions of Part 5. So let me take a closer look at Part 5. What exactly did it do? It creates two regulation-making powers, and then it has a third clause which confers legal immunities on those regulations that are created under those powers. So essentially, a minister can write regulations which are laid before Parliament, and they're subject to an affirmative resolution before they take effect. So Parliament has scrutiny of these regulations, but it's a notorious weak spot of the Constitution, the procedure of parliamentary scrutiny of these regulations, because Parliament cannot amend them, and it typically has a very short time for debate. It's common ground in Parliament that the statutory instrument or regulation-making process has these weaknesses in it. Now, of these delegated powers, the first of them allows regulations to disapply any pre-existing legal requirement that imposes a check or control on goods going from Northern Ireland to Great Britain. And that means these regulations can be used to disapply the Northern Ireland Protocol as well as other provisions of EU law. And the second power is to disapply the EU state aid rules under Article 10 of the Northern Ireland Protocol. And that also allows the government to reinterpret the requirements of Article 10 unilaterally, essentially. Now, these two provisions which create regulation-making powers for the government are essentially concerning in themselves, but they're a prelude to the most spectacular provision of the bill. And I have to say at this point that all of the provisions of Part 5 have been removed by the Lords, and I'll get to what their final status will be, but this is what caused the extraordinary drama. These two regulation-making power provisions are a prelude to another provision which says just what status these provisions have. And I find this clause 45 as it was at the time, it was later turned into clause 47. I wanted to introduce you to some of its provisions because they're quite spectacular So this is the provision that was introduced into the House of Commons, and it simply said those two regulation-making powers that I had just mentioned, they will create regulations that will have effect, notwithstanding any relevant international or domestic law with which they may be incompatible or inconsistent. Now, the fact that they would prevail over international law is very significant from an international relations perspective and also a constitutional one. The one that makes them prevail over incompatible domestic law is incredibly spectacular. Now, another thing that this provision does is it clarifies that these powers prevail over certain sections of the EU Withdrawal Act 2018 that were inserted by the withdrawal agreement. It's an important and central provision of the withdrawal agreement that its provisions have supremacy and direct effect in UK law. That's a provision of the withdrawal agreement that, that requires that very, very clearly. And for added clarity, this provision as it was introduced into the Commons says that, to be clear, relevant international or domestic law includes, and it lists a number of things from A to E, but then in G it says any other legislation, convention, or rule of international or domestic law whatsoever, including any order, judgment, or decision of the European Court. Now what this looks like is that regulations adopted under these provisions are literally above any principle of domestic law, in addition to being contrary to international law. That's quite spectacular for the UK Constitution. This was noticed. So the bill was amended in the Commons. On the 22nd of September, they added the highlighted provisions here. They said, and I believe the intention here of adding these highlighted provisions, and I hope everyone watching can see these a little bit. If you're watching on your phone, you'll have trouble, but I'll tell you what they say. These provisions that were added on the 22nd of September specify that, in fact, you can have proceedings in judicial review. It inserts these provisions that say a relevant claim or application, which is something that can go forward as recognized under what is now subsection 4, subclause 4, includes a claim for judicial review in relation to England and Wales, and there are similar provisions for Scotland and Northern Ireland. So here it seems to recognize that you can have a claim that goes forward whose purpose can be questioning the validity or lawfulness of regulations. Now that seems to be contrary to the initial spirit of the provision, and it raises the question, on what legal grounds could such a claim succeed? If this purports to exclude any rule of domestic law whatsoever, how could such a claim succeed? There was no clear answer to this, and one has to wonder whether the next step, which is also interesting and spectacular for a couple of reasons, is part of a desire to give an answer to that question. Now, as the bill was further amended on report shortly before being passed in the Commons on the 29th of September, they decided that it would be possible to challenge the regulations as being incompatible with the European Convention on Human Rights. However, it would not be possible to quash the regulations due to the incompatibility with the convention. They introduced this provision here, which essentially treats regulations like primary legislation, which changes the fundamental structure of the Human Rights Act. And this was done in a late night amendment, very late in the process in the Commons, with almost no debate whatsoever. Now, I'm not entirely sure why they have added this provision, but one thing it helps them to answer is on what grounds could a judicial review claim succeed under this, against these regulations? And the answer would be, well, you could challenge them for being incompatible with the European Convention without affecting their actual validity. That would be one ground. So they've now, this dramatic passage here says, in the expression relevant international or domestic law includes any other legislation whatsoever, but does not include the convention rights under the meaning of the Human Rights Act. So what they've done here effectively is alter the structure of the Human Rights Act, and they have left open the question of whether a legal claim against the vires of these regulations could succeed on any other grounds. So it really feels to me, as you explore the progress of the bill here, that there's an element of making it up as they go along in a very, very dramatic way for the Constitution. So the provisions in Part 5 on the whole are troubling because they circumvent the dispute resolution process in the withdrawal agreement. They allow the disapplication of the Northern Ireland Protocol. They remove the supremacy of the withdrawal agreement, and they seek to put these powers beyond the control not only of international, but also domestic law, as well as to modify a feature of the UK's Bill of Rights. And all of the above, it has to be added, is done while we're in the midst of two serious constitutional crises, Brexit on the one hand and COVID-19 on the other. Now, it was for this reason that there was a dramatic clampdown on the provisions in Part 5 in the House of Lords. There were condemning reports of the Constitution Committee, the Joint Committee on Human Rights, and the Delegated Powers Committee, all of which attacked the provisions in Part 5. The Constitution Committee notably said that respect for our international obligations is part of respect for the domestic principle of the rule of law. At second reading, Lord Judge moved a motion to amend the second reading debate. The motion said that this House regrets that Part 5 of the bill contains provisions which, if enacted, would undermine the rule of law and damage the reputation of the UK. That motion passed by 395 to 169 votes. And in committee stage, they moved further amendments which removed most of Part 5 from the bill. It's not clear what the government intends to do, whether it is said that it will reinstate these provisions, but they may be playing a long game to see how the negotiations progress, to see if it's necessary to add them back. The EU is taking legal action over the provisions of the bill. That might be something discussed later on, but I can come back to it. I want to conclude very briefly, as I've reached the end of my time, by addressing two main objections to the counter arguments that were made by a number of distinguished peers. One is that the UK Constitution has always recognized that Parliament can legislate contrary to its international obligations, and there's nothing inappropriate here for that reason. Now, the fallacy, I think, in this argument, as recognized by the Constitution Committee, is the view that anything that is lawful is also constitutional, but that is not the case. Parliament can pass legislation that is unconstitutional if it breaches settled conventional norms of the UK Constitution, for instance, abolishing the court system. Another argument is that these provisions are needed in order to defend the integrity of the UK constitutional order, and in particular, uphold the provisions of the Good Friday Agreement. Now, it seems to me that if there were a case for the EU having violated a duty to negotiate in good faith, at that point, the government could take steps to bring these issues to Parliament when they're ripe, and it could take steps under the existing dispute resolution procedures with the EU before doing that. At that point, when the issues are ripe, Parliament could judge whether such powers could be created and what safeguards should be built in. I've not seen any good urgency arguments saying why a fast-track procedure to obtain that end can't be done, and this point has been raised in debates in the Lords, and they haven't either. The 350-page Coronavirus Act was passed in 3 sitting days of Parliament. This is a more straightforward issue, even though it is complex. So I'll stop there and pass on to Professor Rawlings.
Yes, thank you, Jeff. Rick, Professor Rawlings, you're up next.
Thanks, Jeff. I'll follow directly on from Jeff's fine analysis of the bill, and I'm going to proceed in 5 stages. I want to say a little bit more about the context. Then I want to extend Jeff's analysis on the pre-bill process. And I want to say something about the bill as originally drafted. Then I want to say something about the spectacular events in the House of Lords, and then conclude with some pithy comments. And just to explain, I'm not going to be taking Northern Ireland simply because Kimberly and Pete are, clearly going to be focused very directly on that. So by way of context, we're dealing here with what we can call re-regulation in the broad sense of regulating again or anew in the context of Brexit. As Jeff has explained, as the legal corsetry of EU rights and obligations fall away, the question is how the domestic market of the UK is going to be ordered. And first, we were all focusing on the issue of legal stability and certainty, the 2018 Act, and now we're in the middle of a leg fest where the UK Conservative government is bringing forward whole sets of bills to deal and create legal change as it thinks is best appropriate for the national interest. So we mustn't only think about the internal market bill, we must also think about the agriculture bill, fisheries legislation, etc., etc. Second point to make, backing Jeff up, is that the internal market bill really does represent a major policy conundrum, and I'm bitterly critical of it. But I think it's important to note how difficult this one is for Whitehall. How do you secure and promote a domestic market space, not only with a view to the benefits of open competition, but also with a view to facilitating all those promised trade agreements, at the same time as navigating devolved competence and, of course, the overarching commitments in respect of Northern Ireland. And as Jeff has said, not all of those things appear to be being achieved. Next point I think to stress is that we need to see the internal market bill as itself part of a struggle when we think in terms of the territorial constitution, which has been going on all the way since before Brexit, but clearly very intense in the light of Brexit. So there are obvious connections here with the 2018 and 2020 Acts, the Scottish continuity legislation, etc., etc. Where I slightly differ from Jeff is that Jeff talks about the problem of devolution. I would talk about the problem of the territorial constitution, because we all know about Scotland, Wales, and Northern Ireland, or perhaps we don't know so much about Wales, where we might emphasize that we're dealing with the only other devolved administration which is wholly committed to the Union state. But also, really, I think to understand what's going on, we have to understand the situation of England. And we have to remind ourselves that not only is England politically and economically and demographically dominant in our constitution, but that right at the heart of the territorial constitution is the double-hatted nature of UK government and parliament. We have a extremely odd situation, one might say, in comparative terms, whereby Westminster and Whitehall are operating on a UK basis, but are also in practice, post-evolution to the three Celtic lands, operating as the legislature and government for England. And I think that really needs to be stressed, because it helps to explain many of the fears that you will hear expressed in the three Celtic lands relating to the internal market bill. The last point I think I want to make by way of introduction is to remind colleagues that setting up an internal market, there are many policy choices involved in this, and there are lots of choices about the way in which you're going to use law. Are you going to have more reliance on legislation? To what extent are you going to look to the courts? Are you going to emphasize hard law, soft law technique, etc., etc.? And one would not expect to see a single answer to that. as indeed the rich experience of the EU single market teaches us. But I want to emphasize that point because it's a cardinal error to read this bill and see these principles, mutual recognition and non-discrimination, and immediately think in EU terms. To understand how those principles might work, we have to drill down, we have to look at how they are specified in the legislation. And once again, we have to bear in mind the closeness of the UK, and in particular, the dominance in many ways of England. Second set of points I want to make relate to the pre-bill process. Jeff rightly picked it up when the bill emerged and the consultation process. Behind the scenes, and I've been partly involved in this, there's been quiet constitution making going on here for the last 2 or 3 years. Public lawyers haven't really looked at it. They've focused instead naturally on the razzmatazz of Miller and all of that stuff. But it's actually been quite an intense process going on at the official level. And it's involved 3 main strands. The first is work on common frameworks where the respective government officials under political leadership, obviously, have been trying to strike deals about how there might be elements of regulatory harmonization in certain key sensitive areas, such as chemicals regulation, food labeling, waste management, etc., etc. That's the first main strand of the work. The second main strand of the work relates to the market principles, which we now see in the bill. And it's fair to say that the devolves have always been very suspicious of this strand of work. It's very much a UK departmental strand of work. And the third one is the work around intergovernmental relations, a long-standing interest of mine, a black hole in the Constitution, where the UK government has not exactly distinguished itself in promoting fair, accountable and transparent procedures. Now I say all that because the bill focuses very much on the first strand when you look at it in terms of the territorial constitution. You wouldn't expect to see much in the bill, I think, about the third strand, IGR, but it is a very striking fact that the bill as originally drafted has nothing at all to say about the common framework strand. That then brings me to the bill as originally drafted from a territorial constitutional perspective, and a number of points to make. First and foremost, the absence of any mention of common frameworks on the face of the bill. So, if you like, it's in policy terms utterly incoherent because the work has been going on this for 2 or 3 years, and it's as if the UK government has just turned around with a big meat cleaver and said, oh, well, we're simply going to cut all that work off. And I cannot overstate, colleagues, the extent to which, well, I could think of some language in which to put it, but since this is being recorded, I'd better not. The extent to which this has made the devolved administrations, shall we say, cross, because they have spent considerable time and energy and resource in attempting to work collaboratively with the UK government for the last 2 or 3 years. You get Jeff's part of the process, and suddenly that work all disappears over the horizon. The second key point to make about the bill from this perspective is how narrowly drawn in the original drafting are the exceptions from the application of the market principles. And you see there quite a big distinction from what you'd find in the EU. In turn, you see a heavy emphasis on proportionality testing, which inevitably brings in the role of the UK Supreme Court, which some may think is very interesting, given another stream of government work that is going on, which seeks to put in issue the role of the Supreme Court in our Constitution. The other point, the other 2 points I'd want to stress, the first one picking up on what Jeff said around the CMA, the Competition and Market Authority, the reliance on a UK level authority with very little ownership or buy-in from the devolveds. And last but not least, what I'm going to describe as the tack-on, which is you suddenly find in the Internal Market Bill attempts by the UK government from a devolved perspective to invade the devolved decision-making space in two main ways, both financial ways. First, by powers to carry on infrastructure type developments in areas of devolved competence without the agreement and collaboration of the devolveds. And secondly, an assertion firmly resisted by the devolved administrations, but a legislative assertion in the bill that state aid policy is to be reserved to the UK Parliament. Right, that takes us to the House of Lords, which is where a lot of the action has been. And Jeff was talking about what's been happening in the House of Lords. And interestingly, a lot of what Jeff was talking about happened at committee stage, which is very rare in the House of Lords. And it shows you quite the controversy that has been caused there. If we look at reports, we see a heavy focus on the territorial constitution at this stage. And essentially, we see three things going on: gutting, elaboration, and construction. I'll pick out four main points. First, Lord Hope. Interesting to see eminent lawyers coming in here. Lord Hope's amendment, new clause 2 around common frameworks, putting back in this major strand of work into the bill and saying that the market principles are not going to apply where the parties have made a common framework agreement. So really a restatement of the importance of collaborative, political, administrative, intergovernmental work in the construction of the architecture. Secondly, as one would expect, a rather more generous view of the exceptions to the market principle, revised clause 11. And then third, and here we see Lord Thomas of Cumgeath being very active, so we have a restatement of, or rather we maintain devolved aids, and indeed we strengthen the agency there, the Office of the Internal Market from a devolved perspective. Is that House has deleted the power to fund infrastructure developments in the areas of devolved competence. So quite a struggle going on there, and it'll be interesting to see how much of that the Conservative government puts back.
Rick,
so
sorry,
to end with some pithy.
Can I jump in for a second, Rick? 1 minute, but also your Wi-Fi is just shaky. So maybe, oh, I think you're back now. You were just, you were cutting out a little bit, but I'm also giving you a 1 minute warning.
I'm on to my pithy comments, Eloise.
Good. Well, great.
That should take all of 1 minute. Wonderful. My pithy comments are as follows. First, the significance of this cannot be underestimated. We are dealing here with arrangements which will go on way beyond the transition period and go directly to the relationship of the four countries. Secondly, the arrangements, if they are put back anything like they were as originally drafted, load the situation even further in favour of England at the expense of the other three countries. Third, as I've tried to emphasise, the legislative policy development is incoherent. And fourth, we note the very aggressive use here in this aspect as well of parliamentary sovereignty. There's little by way of sensitivity, there's little by way of sensibility in terms of the territorial constitution. So to finish, last but not least, and here I speak as someone who is in favour of the Union State, the government's approach reeks of unionist folly. Diolch. Thank you.
Thank you very much, Rick. I'm going to move us straight on to Professor Kimberly Trapp.
Thank you. So I'm going to be addressing the public international law aspects of the Internal Market Bill, the IMB. I don't know that I will end with anything as pithy as Rick, but I'll do my best. First, I want to touch briefly on something that Jeff touched on, which is to say that the separate legal dimensions or planes or spheres at stake in discussions about the IMB. The domestic sphere on the one hand, in which parliamentary sovereignty operates, and the international law sphere on the other, in which it does not. A relatively common feature of government statements, and I have in mind in particular those by the AG to Parliament and HMB's legal position, is that they're a bit naughty or vague in distinguishing between the domestic and the international. For instance, the AG's suggestion that parliamentary supremacy prevails over international law, or in the legal position that under the dualist approach, treaty obligations only become binding to the extent that they're enshrined in domestic legislation. Now, whatever the truth of these positions as a matter of UK domestic law, they're very evidently not true as a matter of international law. And the statements seem to very deliberately leave this unsaid. Under both the law of treaties and the law of state responsibility, domestic law is not an excuse or justification for breaching international law. The fact that a sovereign state or indeed a sovereign parliament can breach international law, that's a statement of fact. It's not a statement of international law. And the deliberate or not sloppiness around this issue obscures a little bit what's at stake and seems to extend the rhetorical battle between EU law and UK sovereignty to international law and UK sovereignty. But entering into treaty relations is, of course, not a challenge to sovereignty, it's an exercise of sovereignty. Perhaps more worryingly, relying on UK parliamentary sovereignty as a source of seeming right to breach international law, it undermines the UK's standing and capacity to call on other states to respect their international obligations. And I would say that times are a bit tough out there in the international sphere or on the international plane, whatever you want to call it. And we need for states to be able to credibly stand up for an international rules-based system. In certain parts of this bill and the rhetoric around parliamentary sovereignty, really it undermines the UK's credibility in this respect. So it's all very strange, and I expect this has contributed a fair amount to the frustration that so many international lawyers feel with the Internal Market Bill and the justifications for the positions adopted therein. And that brings me to the second issue that I want to look at, which is what is the PIL, the public international cause for concern here? Is the Internal Market Bill itself a breach of international law? And there's a temporal aspect to this question. In respect to some of the provisions as introduced, there's a strong argument to be made that they are themselves in breach of the withdrawal agreement or the WA as and when adopted. And in respect of other provisions, the breach is potential or I guess anticipatory in some sense. So let's start with the immediate breaches because these are pretty straightforward and much has already been said on them. So in particular, the notwithstanding clause of the IMB, which in its original form overrode the provisions in the EU Withdrawal Act, according direct effect and supremacy to the provisions of the withdrawal agreement within UK domestic law. So Jeff spoke to this. Well, the ouster of judicial review seems to have been varied, so there are various amendments applying to it. It remains in pretty clear breach of Article 4 of the withdrawal agreement, which stipulates that the provisions of the WA have direct effect within the UK's domestic legal system. And to the extent that it does oust judicial review, it may also be in breach of the obligation of good faith set out in Article 5 of the withdrawal agreement, which can be understood in PIL terms as a particular treaty instantiation of Article 26 of the Vienna Convention on the Law of Treaties, or the VCLT, that every treaty in force is binding on the parties and it must be performed by them in good faith. And this forms part of the basis of the European Commission's commencement of infringement procedures against the UK for the breach of the WA in respect of the Internal Market Bill. So certainly a space to watch. What I really want to spend more time on, though, are the potential breaches of PIL, because they're a bit more complicated. As Jeff explained, the IMB gives the government the power to make regulations to disapply bits of the Northern Ireland Protocol in respect of exit procedures applicable to goods moving from Northern Ireland to Great Britain, and in respect of state aid. The exercise of either power could result in a breach of provisions of the Northern Ireland Protocol and the WA, the breaches occurring if and when those powers are exercised. Now, there are, of course, developments in terms of the legislative process here, including in respect of the entry into force of these provisions, the Lords voting to remove the powers, and in respect of these powers potentially being included in a money bill to be put before Parliament maybe next week. But I want to focus on the PIL analysis of the provisions as introduced in the IMB when coupled with a government statement on these powers. So in a government statement on these notwithstanding clauses, the government commits to only asking Parliament to support the use of the provisions of the IMB in the case of, in its view, and that's quoting from the statement, in its view, the EU being engaged in a material breach of its duties of good faith or other obligations, thereby undermining the fundamental purpose of the Northern Ireland Protocol. The government statement goes on to list examples of what the UK government would consider to amount to such a material breach. And there are two international law readings of these IMB notwithstanding clause when coupled with the government statement. The first is a treaty law reading under Article 60 of the VCLT on the Vienna Convention on Law of Treaties, such that the government is giving itself permission in advance to partially suspend its obligations under the withdrawal agreement, the Northern Ireland Protocol, in the case of a material breach of that agreement by the EU, with material breach defined under the VCLT as the breach of a provision essential to the accomplishment of the object or purpose of the treaty. Now, the government statement doesn't quite replicate the language of Article 60, but it does use the term of art material breach and references the fundamental purpose of the Northern Ireland Protocol, which can obviously be understood in terms of object or purpose. Given that language, the powers to disapply bits of the Northern Ireland Protocol contemplated under the IMB may be recognized as a matter of PIL treaty law, insofar as those powers are generally used to respond to a prior material breach of the treaty by the EU, material breach as understood under international law. The other reading of the IMB notwithstanding clauses on exit procedures and state aid, again, when read in conjunction with the government statement, is a state responsibility reading, contemplating the adoption of countermeasures. Countermeasures are a reciprocal breach of international law adopted by an injured state against a wrongdoing state with a view to bringing the wrongdoing state back into compliance with its international obligations. In one sense, the UK is contemplating reciprocal breach here. The government statement makes it clear that it will only ask Parliament to support the use of the offending clauses if the EU breaches its obligation of good faith under the WA first. But the state responsibility reading is somewhat less plausible than the treaty reading, even if still possible. First, the adoption of countermeasures under international law isn't contingent on the initial breach, in this case by the EU of good faith obligations, for instance, being a material breach, which undermines the purposes of the relevant treaty. So query why include such restrictive language in the government statement if what they were contemplating were countermeasures rather than suspension in response to a material breach. In addition, we have to factor in the government's commitment in its statement that, and I quote, in parallel with the use of these permissions to breach the withdrawal agreement, it would always activate appropriate formal dispute settlement mechanisms with the aim of finding a solution through this route. Now, that commitment puts a time limit on countermeasures, which have to be suspended if the dispute is pending before a court or tribunal which has the authority to make decisions binding on the parties. accepting that there could be at least a 3-month delay in constituting an arbitral tribunal following allegations of a breach, and this assuming that consultations in the Joint Committee fail to produce a mutually agreed solution. There is some time within which to adopt countermeasures, but not much. Of interest from the public international law perspective is that these powers to suspend a treaty in whole or in part in response to a material breach by the other party, or to adopt countermeasures in response to a prior internationally wrongful act. These are part of the general international law framework within which any treaty sits. The treaty doesn't need to set them out, although it may vary the availability of these powers by way of lex specialis, and I'll speak to that in a minute. So suspension in response to a breach or countermeasures in response to a breach, they're built into the international law cake. And what we potentially have here is one or both of these being contemplated in advance within domestic legislation giving effect to the treaty. But there are two further issues here. First, the government statement is not part of the IMB. The conditions the government has set for itself before it puts to Parliament the exercise of the powers to breach the Northern Ireland Protocol are not legal conditions constraining the use of those powers within the primary legislation granting them. The government could choose to exercise the powers it has granted itself to act inconsistently with the Northern Ireland Protocol in circumstances which are beyond those set in the statement, or even if in keeping with the statement in circumstances which are not recognized by international law. And there are certainly questions around whether the statement perfectly captures the law of treaties and state responsibility here. So the exercise of the IMB powers at the time they're exercised may well breach the Northern Ireland Protocol in circumstances that treaty law would not permit, or that the law of state responsibility would not preclude the wrongfulness of. The second issue is in respect of the dispute settlement provisions in the withdrawal agreement, which are set out as the exclusive means for resolving a dispute and include a right to temporarily suspend compliance with obligations in response to non-compliance with an arbitral decision. There may be a case to be made that these are a lex specialis, which displaces the general international law, treaty, and state responsibility regimes. What this would mean is that the right to suspend in whole or in part in response to a material breach under the VCLT, or to adopt countermeasures in response to an internationally wrongful act, these would not be available in respect of the WA. And whether the government complies with the conditions it set for itself in its statement or not would be immaterial. The use of the IMB powers in circumstances which are not contemplated by the dispute settlement provisions of the withdrawal agreement would be a breach of the withdrawal agreement. And to the extent that the WA is a lex specialis in this regard, the general international law of the treaties or state responsibility wouldn't fix this. But assuming for the moment that the general PIL treaty law and state responsibility regimes remain applicable, and that the government statement on the use of secondary legislation under the IMB is coextensive in at least some respects with international law, and assuming that the government sticks to its statement, so assuming a great deal, the use of the powers in the IMB could simply replicate in domestic law the position at international law. And the position at international law does recognize that states sometimes act in breach, and even material breach, of their international law obligations. Now, for the UK to anticipate that the EU will do so, while itself breaching international law, even if in specific and limited ways, that may not be, it may not be bad faith, but it is almost certainly a lack of faith, or a concern that what goes around comes around. And that is certainly a very worrying aspect of all of this for the prospects of a close and productive future relationship. And I think I will leave it there for Pete to pick up.
I'm going to hand over to you, Pete.
Thank you very much, Eloise, and it's wonderful to see, between inverted commas, because we cannot see you, but so many members of the laws community at this seminar, and I'm grateful for Eloise for setting it up. I'm going to not accept the assumptions which Kimberly just put forward, and I'm going to speak about the provisions in the Internal Market Bill on the breach of international law without sort of taking the statement on board and believing that that is the way in which the government would use it. And my comments are a little bit more wider. I would like to say a few things on the nature of the international law violation we are talking about here, and to contrast it with other kinds of violations, particularly in a European context. And it's always useful, of course, in a debate to have a counterpart. So some of you may have seen a piece by Professor Joseph Weiler in EGIL Talk, a blog post where he claims that the UK's behavior is not terribly extraordinary because many states and the EU itself violate international law. And I quite violently disagree with that assessment because I think we're looking at something else. Now, obviously, as a starting point, states and international organizations like the EU will from time to time violate international law. Of course they do. There would be no need for law, there would be no need for international law if there was not a risk of violation. That's why we have international adjudication and dispute settlement. If states always agreed on everything, no law would be needed. But clearly some violations are more blatant and flagrant than others, including in the European context. So why is this case different and why is the indignation justified? And I have 5 points to make in that respect. First, it's already been mentioned a couple of times, I'll be brief on that. The nature of the agreement itself, the withdrawal agreement, let's never forget that, creates directly effective rights for not just the parties to it, the UK and the EU, but for any private actors, any companies, any persons who have rights under the agreement, under Article 4 of the withdrawal agreement. And in the context of these particular provisions in the Internal Market Bill, I'd just like to highlight Article 4, paragraph 2 of the withdrawal agreement, which provides that the UK shall ensure compliance with the agreement, and I quote, including as regards the required powers of its judicial and administrative authorities to disapply inconsistent or incompatible domestic provisions, end of quotation. So in fact, the withdrawal agreement is pretty extraordinary because it's one of the few agreements or treaties I know which explicitly incorporate both the direct effect of the agreement and its primacy over inconsistent domestic law, very much in line with what are basic EU law principles, but which have never been put into the treaties themselves. Now, obviously, also the Irish Protocol to the withdrawal agreement benefits from the direct effect and primacy of the agreement, including its provisions on state aid, to mention those, and those provisions confer rights on private parties. So as the agreement stands, a competitor may, for example, rely on state aid law to challenge aid to an undertaking in Northern Ireland as being unlawful. And that could be taken away by the exercise of this regulatory power. So this means that the authority which the Internal Market Bill gives to the executive to essentially overrule some of the provisions of the Irish Protocol affect not just the protocol or that particular issue, but really undermine the very nature of the withdrawal agreement. Second point is that the provisions of the Irish Protocol, which are the focus of the Internal Market Bill, are really vital to the functioning of that protocol, which in turn is vital to the functioning of the withdrawal agreement. Take again state aid. Clearly the ability of the UK government to subsidize at will companies in Northern Ireland would undermine the very integrity of the EU internal market, because Northern Ireland is effectively kept inside the internal market of the EU, and companies in Northern Ireland are direct competitors of EU companies in Ireland or elsewhere, because they can trade freely like any business set up inside the European Union. The provisions on goods at risk, which are intended to be part of the finance bill, they threaten to strike a really big hole in the EU's external border. Because if the UK government can again decide unilaterally which goods, when moved from Britain to Northern Ireland, are at risk of moving into Ireland, and therefore into the EU for customs purposes, then Britain-Northern Ireland trade could become a really big conduit for avoiding EU tariffs. Take an example, cars produced in Great Britain, if there is no deal, they would be subject to a tariff of 10% for importation into the European Union. But if they can just be shipped to Northern Ireland and the UK government determines that they are not at risk of moving into Ireland, and then they do move into Ireland, that of course would be an incredible hole into the EU's external trade border. Third, a comparison. Would the European Union be able to violate the withdrawal agreement in this way? The emphatic answer is no. The agreement is clear about its direct effect, and any attempt by the EU legislature to authorize the EU executive, which would be the Commission in this case, through implementing regulations. So to authorize the EU executive to disregard the provisions of the agreement would on its face be a violation of the EU treaties. Agreements concluded by the European Union are binding on the institutions of the European Union and on member states, and any interested party, be it a company, private person, could rely on the agreement against inconsistent EU legislation because the agreement has direct effect. And I think under EU law, even if this was an agreement which did not have direct effect, I would still argue that the European Court of Justice would find an express legislative authorization to disregard a binding agreement to be flagrantly unlawful. Legislating in a way which amounts to a violation of international law is one thing. Legislating so as to give the executive a general license to disapply international law is a different thing altogether. My fourth point, how about other instances of violation or alleged violation of international law, particularly in the European context? And let's focus a bit on courts, because court decisions have been invoked to show that also others are sinners. So a general comment to begin with. The cases to which often reference is made, such as Cadi, I'll come to that, and Weiss of the German Constitutional Court, but also the Italian Constitutional Court, all of those cases involve tension, or perceived tension at least, between fundamental rules and principles of domestic law and international commitments. The courts, when they are faced with cases, need to face up to that tension, and they are generally instructed by the Constitution or by the EU treaties, in the case of the EU, to uphold those fundamental rules and principles. This has spawned the voluminous literature on legal pluralism. Courts may decide such cases in more or less convincing ways, and that is a beauty which is often in the eye of the beholder. I think, for example, that Cadi was correctly decided and that Weiss is incorrect, but it's not difficult to find someone else with exactly the opposite view. But is that in itself not an indicator that these cases are very different from the express flagrant violation in the internal market bill? And I do not easily accept the political rhetoric that the provisions in the bill are required to uphold the UK Constitution or the integrity of the UK internal market. I really do not see what fundamental domestic laws govern that integrity and are in tension with the withdrawal agreement. So in terms of cases, let me just mention one, which I know really well because I was quite heavily involved with it. It's the Cadi case. Many of you will have heard about it. Famous, some say infamous ruling by the European Court of Justice where it disobeyed the UN Security Council. The UN Security Council which listed Mr. Cadi as a supporter of terrorism and had his assets frozen. The ECJ decided that Mr. Cadi's rights of defense had not been respected. Isn't that also a specific and limited violation of international law? Well, no, in fact, it isn't. And it's a case which shows that case law cannot easily be summed up in one-liners or worse slogans. The ECJ was actually careful to state that its rulings in no way affected the binding effect of the relevant UN resolution and its primacy under international law. And those statements were not just slogans. Those who know the case well are aware that the EU kept Mr. Cadi on its counterterrorism list for longer actually than the UN did, because even after the first judgment of the European Court of Justice, the listing was maintained. And it was only after the UN had delisted Mr. Cadi that he was delisted by the European Union. So there was never actually in that case a violation of international commitments. In the interest of time, I'm going to skip what I was going to say about any EU legislation. I do want to say a couple of things by way of closure on the point of the sovereignty of UK Parliament and how that links up with respect for international obligations. And these are really genuine questions which I have. They may sound rhetorical, but they are really genuine. But I think they strike at things we need to think about. So how absolute is the sovereignty of Parliament, and what is its relationship to the rule of law and to the rule of international law? Does parliamentary sovereignty mean that the rule of law itself can be set aside? That's difficult to accept, of course, because Parliament makes laws, and how can there be laws without a rule of law underpinning it? And remember that the withdrawal agreement is a directly effective agreement, which Parliament has itself incorporated into domestic law. And yes, Parliament can change any laws, but should it be allowed to change laws which have been agreed internationally by the UK in the exercise of its sovereignty, without the UK following the international routes to amendment, to withdrawal, or to any other remedy? So these are really very important questions, I think, which the bill raises, which sort of complement the questions which Jeff touched upon at the start of this seminar, the extent to which the rule of international law is also part of the rule of law, particularly for an agreement like the withdrawal agreement. So I'll conclude there, and so that we have some time for questions and discussion. Thank you very much.
Thank you very much, Pete. Okay, I have got a few questions already. I've just seen another one come in, which I will come to in a moment. I'm going to pose some questions to each of you individually, if that's all right, to try and keep some order. First, I'll come to Jeff, a specific question and a general question. So the specific question, which has been posed to you by one of the audience members, is, other than the Human Rights Act, which other UK legislation, and I guess, and doctrine potentially, could be used in judicial review against any ministerial regulations that come through that disapply day one obligations of the UK? Maybe I'll just let you deal with that first.
In brief, I think that it probably wouldn't be other EU-related statutes. You'd have to disapply the provisions of the Internal Market Act, and you'd probably, the only power to do that really, I think, would be under this doctrine of constitutional statutes. So you'd need to find another statute that is considered constitutional and is inconsistent with the Internal Market Bill, and it wasn't an express or necessary implication of the Internal Market Bill that intended to amend that kind of provision. So I think any EU-related legislation it is a necessary implication of the Internal Market Bill that it intends to modify those statutes. It's possible that devolution statutes might be affected in some way that doesn't seem to be the necessary implication of this bill. That is a possibility. I don't know whether it would be decided. Generally, I think the vires of these instruments would be controlled under common law doctrines of reasonableness, respect for common law rights, and so on. I think that the courts will probably, if pushed, read down these provisions, referring to those kinds of doctrines, and probably only in fairly extreme cases.
And the more general question, which is also from a member of the audience view, is recent legislation introduced by the executive, the Internal Market Bill, the Coronavirus Act, and I chair inserting the Environment Bill, the Fixed Term Parliament Act Repeal Bill, etc., are shifting powers from the legislature to and empowering the executive. Is it time to revisit the concept of parliamentary sovereignty?
My view on that is that you could either think that parliamentary sovereignty is part of the problem, or you could take the view that there was a political constitutional understanding that Parliament should have a particular role and strength in the British Constitution that has deteriorated. So in these examples. So I think the point could cut either way. Those who have no truck for a written constitution and judicial review are just as appalled by these moves as are those that respect the political constitution are as appalled by these moves as are those who want a written constitution and judicial review.
Great. I'm going to move on to Rick. There's a again a quite specific question that was addressed to both Jeff and Rick, but I'll give this one to Rick, which is about scrutiny of statutory instruments. So the question is that scrutiny of statutory instruments is often perfunctory if it occurs at all. Recently, there has been an idea floated for allowing statutory instruments to be amended before a vote. One hopes that this could encourage parliamentarians to pay closer attention to the contents of regulations. Can you see this kind of power being introduced? And if so, how would it be affected? Does it require amendment of the Statutory Instruments Act 1946? Thoughts on that, Rick?
That's a nice question. And I think since I'm clearly the person doing pithy comments this evening, I think my response would be smell the coffee. I mean, I just don't see in the present constitutional and political context in which we find ourselves, the current UK government suddenly deciding on a new process that it would push through the House of Commons, whereby lots of regulations, prospective regulations, would be open to amendment. I just think that is off the radar screen when I look at the constitutional conditions which we are currently experiencing.
And another question for you, I think I'll give it in two parts, Rick. So should we be surprised at all by the attitude of the UK government towards the common frameworks and the devolved administrations more generally, given the power grab evident in the Withdrawal Act? So that's kind of, should we be surprised? And I'd add to that about common frameworks. I mean, you gave some really helpful background on the role of common frameworks and how there's been this constitutional kind of constitution building going on through the work of civil servants. And the question I'd pose about that is, how would we legislate for or constitutionalize those kind of common frameworks? Would we do it in a piece of legislation? What kind of a bill could we imagine?
Okay, so two-part question. Well, the first is, I suppose I'm a natural optimist, so I always hope that lessons may be learned and all of that. Evidently, on this occasion, lessons have not been learned. And I mean, I think it's common knowledge that there's been quite a big debate inside Whitehall between, shall we say, hawks and doves and people in between. And under Prime Minister Johnson, the hawks have rather had it when it comes to the Internal Market Bill. So I would say that I'm not surprised, but I'm disappointed. And I just want to reiterate the devolved administrations, if you talk to officials in the devolved administrations, they will say that they feel they've been led up the garden path, that they've been really intimately involved in work around the framework process, and this has suddenly, sort of disappeared over the horizon. The second one, in relation to framework legislation, I mean, the idea of framework legislation and the framework process is really to isolate particular areas where there are significant fears around possible regulatory divergence in areas where the devolved administrations have competence. Because clearly, if they don't have competence in the first place, there's not much of a difficulty here, right? And in a way, it depends on the way in which you wish to approach things. Do you then wish to approach things through general principles, which are essentially allowing powerful commercial interests to work as private attorneys general across the board, with the consequence that the devolved administrations are going to find this process very enervating, because should they wish to innovate in these kind of areas, they are running the risk of litigation? Or do you want to look at it from the other way round and to say, look, devolution is the norm, divergence is perfectly acceptable, and that where there is a real issue, we target that issue and we deal with it either through legislative means or non-legislative means. And doing it that way, one could think in terms of various forms of subject matter legislation. So, for example, there is a whole set of areas in relation to agriculture involving common frameworks. One would be thinking in terms of the Agriculture Bill as the appropriate vehicle for the common frameworks which were thought to require legislative backup being dealt with in that kind of subject matter legislation.
That's really helpful. Thank you, Rick. I'm going to turn to Kimberly because everyone's getting a question. I mean, this is also a kind of the intricacy of what's going on here in PIL terms is what is so striking about your presentation. And I kind of there are two questions I'd like to pose on that. Is, you know, have you seen anything like this in international law before, where a state anticipates breaches by another country and kind of sets up its provisions for countermeasures at the same time as breaching in international law? I mean, are we in really novel territory? And then the hard question is, I think I know the answer to that, but you're the expert, not me. It is, what can international law do about any of this?
Yeah, really good questions. In terms of the practice, I'm not aware of states sort of anticipating in advance a breach by a treaty partner and incorporating into their domestic legislation, giving effect to that treaty, powers that are recognized as a matter of international law, but you wouldn't normally expect to see replicated in domestic law. Having said which, when I was thinking about this, so I have to confess that I was a bit surprised by the intricacy of all of it, simply because my gut reaction as an international lawyer was outrage. And I had to remind myself that we have a lot of UCL trained lawyers who are government lawyers, and they're smart cookies. And to sort of take a step back and think, what on earth is going on here, basically, because it can't just be that outrageous a breach. And so I thought it was a really helpful exercise to kind of dive into the details. And in one respect, when you have a piece of legislation that is giving effect to a treaty, the powers that exist in international law to sort of respond to a breach of that treaty by the other party, there would be no space for them in the domestic legislative framework unless they were provided for, right? It's almost as though they would have to adopt new legislation to provide for the adoption of countermeasures or suspension of a treaty in response to a material breach. So in some respects, I understand a little bit possibly including these powers in the legislative framework that's giving effect to the treaty. Having said which, the government statement isn't part of the IMB. So it's very clear that this was something that they thought of after the fact. The way in which the powers are framed in the IMB are incredibly broad, aren't restricted in the way that international law would restrict suspension or a reciprocal breach, right? So the legislative framework itself isn't restrictive. It's when you read it in conjunction with the government statements that you start to see that there might be something here. But the IMB on its own is simply authorizing a breach of international law, which would be significantly broader or potentially significantly broader than what international law would recognize. So I haven't seen this. I can't remember what your second question was.
What can international law
what can we do about it?
Oh, Pete's going to answer that question. Pete would like to answer that question.
Okay. So to the extent, let's assume for the moment, and again, it's assumptions that I think Pete quite rightly pushed back on, because I was asking us to assume an enormous amount. But let us for the moment assume that we're reading the statement in conjunction with the IMB, that the power to suspend or adopt a reciprocal breach is precisely coextensive with powers that exist in international law. So it is exactly when international law would recognize the power to partially suspend in response to a material breach, or the power to adopt countermeasures in response to a prior internationally wrongful act. So let's assume all of that is exactly coextensive. And the legislative framework is simply recognizing that there may be cause to act in breach of treaty obligations responding to a prior breach. And let's not forget that the government statement makes it relatively clear that this is in response to a fairly serious prior breach by the EU. Now, the fact that they're assuming that that might happen is a whole different question, right? But that is the premise of the exercise of these powers if we read the government statement in conjunction with the IMB. I struggle from an international law perspective. From a domestic law perspective, there might be all sorts of things wrong with it. But from an international law perspective, I struggle to see what is so flagrant or what is so terrible about a state recognizing to themselves powers that international law recognizes, basically. Pete might have a very different view of that. We sometimes have very different views about these things.
Pete, I'm saying, would you like to answer that question?
Yeah, can I just come in there? What I find, I mean, certainly if we take the statement very seriously, I can see how this can be construed as just giving the government the opportunity to respond to breaches of the withdrawal agreement by the EU. But why then is the power given to the government so specific in terms of specific provisions only of the Northern Irish Protocol? Why doesn't it say generally? And it should have been done then, I think, in the earlier act which approved the withdrawal agreement. Why doesn't it say generally that Parliament gives the government powers to respond to a material breach of the withdrawal agreement by the EU? No, this is really specifically on state aid, on exit declarations, and on goods at risk of moving into EU territory. So that suggests to me that there's another political underlying purpose of identifying those provisions. And I think it could be to just try to force the EU to make a deal, and if there is no deal, to force it to put up a border in Ireland.
So I completely agree that the context makes me very concerned about what the underlying motivations are here. Having said which, the fact that it's a very particular exercise of a broader power it doesn't itself render it. So just looking at this purely from an objective legal perspective, without my sort of, international law outrage and all of this, just from an objective legal perspective, that alone doesn't render it unlawful. It makes it very suspicious, but it doesn't render it unlawful. So that's, I think, what I really struggled with.
There's another question for you, Kimberly, but I'm just going to ask Pete one thing, and there's after Pete, then Kimberly, then Jeff, I think, and then we'll have to wrap things up. So Pete, quick question, hopefully, is there going to be a short answer in the Court of Justice challenge to the Internal Market Bill from the Court of Justice?
I think there's going to be a very short answer, yes, that the withdrawal agreement was not respected. Yeah,
okay. And wait, do we know when this is going to come? We don't know.
I haven't checked whether they're going to. I don't think at this point in time there's probably any intention to prioritize this case and to deal with it any faster than any other case, because the negotiations are ongoing. But those things might change, and the Commission might always at some point go back to the court and ask for this to be dealt with as a priority, although there's nothing much that the court itself can do about the breach.
Yeah. Thank you. Okay, so question. I'll come back to Jeff next. There's a question. Well, it's actually to everyone, but I'm going to pose it to Jeff first. And Rick, if you want to come in on this, do hold up your hand. So is there a danger of executive abuse in light of the large amount of EU regulation being transposed into UK law through the UK Withdrawal Act via the ability to alter secondary legislation to ensure its application when the UK leaves the EU? And if so, is there a more democratic way to implement this that preserves parliamentary sovereignty, or is this approach a necessity? I mean, this is quite an academic question considering this has been largely done already, but Jeff, yeah.
So this was the main dramatic issue discussed by the Constitution Committee in considering the EU Withdrawal Act of 2018. And they created a separate process for sifting statutory instruments to upgrade scrutiny in Parliament of these instruments. And I think essentially there might have been a different way of bringing all of that EU law onto the statute book other than in this way, perhaps by coming up with sort of area by area statutes. But that was considered to be impractical and unfeasible at the time. It was criticized, but there wasn't a whole lot of support even from those committees for doing it all by statute for that idea. And furthermore, the practice of the sifting committees has been that for the most part, the instruments that were created do largely transpose the existing law into UK law without, in most cases, having major questions of policy decided. It's not been the case across the board, but for those who are fiercely critical within the system, they've been surprised that there was less big policy being decided in that process than they had expected to see. And that's my experience too.
Great.
Not to excuse any of this, but I'm just saying that that's where practice has gone since 2018 on this question.
Great, thank you. Rick, did you have any thoughts on that extraordinary process that government has gone through? Another question, I'm going to come back to an international law point in a minute, but while we're talking about parliamentary sovereignty and what's going on in Parliament, it seems like the government is in the same bill using parliamentary sovereignty to justify breaking international law whilst also undermining parliamentary sovereignty by, acquiring itself wide de facto regulatory powers. Do you think that the old political understanding of Parliament's role can be recovered? If not, where are the options beside Lord Hailsham's elective dictatorship and a more continental style constitution? Rick, that was for Jeff, but I might bring Rick on that one first to share out the questions.
Unmute, Rick.
Yeah, unmute. Yeah, great.
I've unmuted. So I was rather anticipating that at some point we would ask that sort of, is this the written constitution question? Well, again, I think I do think I have to answer, sort of smell the coffee here, right? I mean, it may be, right, that the longer view, right, is that what is happening here really does prompt a real look at our whole constitutional arrangements in terms of these constitutional fundamentals. But it seems to me, again, looking at this from a territorial constitutional perspective, it seems to me that we're in such a crisis in the territorial constitution, especially because the Scottish government clearly wants to leave the Union if it possibly can. And I think we can all reasonably anticipate that the Scottish government will win a thumping majority in the Scottish Parliament elections next May. That it seems to me that any serious attempt at a codified constitution in these conditions is, again, not really a viable option.
Thank you for answering that question. We're nearly out of time, so last question. I'm going to come back to international law, and this is addressed to you, Kimberly, but I think to you and to Pete. See if you can exercise your imaginations for an answer on this. So as Kimberly, as Professor Trapp said, the UK is standing on the global stage, and authority to call out other nations' misbehaviours is damaged by the Internal Market Bill. Unfortunately, trying to speak legal truth to power is falling on deaf ears in the government. Can you provide an example of where the UK would be truly hurt if what goes around comes around? The kind of example that might be sensitive enough to focus the minds of the Attorney General and others in Cabinet.
Really good question. Really good question. And I think I'm going to rely on a speech in the House of Lords to answer it. So Lord Ricketts had something very chilling to say on precisely this point, and I will be forgiven reading his speech because it is, it's just very well said, and I don't think I can say it better. But he says, "I invite noble lords to come with me across the road to the Foreign Secretary's grand office on King Charles Street and to imagine that he summoned the Chinese ambassador to upbraid him on his government's crackdown in Hong Kong on fundamental freedoms. The Foreign Secretary would tell the ambassador this is a flagrant breach of the international agreement China signed with Britain in 1984 to uphold Hong Kong's way of life for 50 years. The ambassador might well say, I agree, this is a breach of international law in a limited and specific way, but be reassured, Foreign Secretary, it is perfectly legal in our domestic law. The National People's Congress has legislated to repudiate parts of that 1984 agreement. That is our sovereign right. How is the Foreign Secretary to respond if these clauses stand part of this bill and become law? Every other Foreign Secretary would have said pacta sunt servanda, and he would have had centuries of British practice behind him to give that weight. What would the current Foreign Secretary be able to say if this became law? Pacta sunt servanda when it suits us does not quite have the same ring. Yeah, exactly. So I think I will leave it at that.
Pete, would you like to add anything? I think that was a nice note to end.
Just here. That's all I can add.
A huge thank you to the panel this evening. We've kept to time. We've managed to cover a huge amount of ground. I think maybe we can make a commitment to our students not to set the Internal Market Bill in a problem question, but watch this space, a huge amount of certainly complex and important legal issues. So thank you to all of you. Thank you to our audience. There's been a lot of you participating and listening and watching. We have recorded this session, so you can watch it again if you like. But I will draw proceedings now formally to a close.